Today I'm joined by Shelley Eden, Director of law firm GazeBurt and a long-time employment law expert, to talk about some key employment issues of late. And Shelley, it's really all about Uber this week, isn't it?
Yes, look, I think it's everywhere. It's unmissable, it's unavoidable, and it's important. So it's a good topic for discussion.
Right. Now, tell us what was decided, top line, sort of.
So top line is that the Employment Court made a declaration that 4 Uber drivers who worked for the Uber companies, as they're known, were declared to be employees, not contractors. The slightly wider context to that is that the union made the application, Air2 Union made the application on behalf of the 4 workers, and the Uber model is that all of their employees who are actual drivers, all the people who are drivers, are currently engaged as contractors. So it's a dramatic change of status for those 4.
Absolutely. And the judge really honed in on the idea of what the real nature of that work relationship was. Can you explain a little bit about that?
Yeah, sure. So there's always been this, there's a history of cases trying to look at whether a person is an employee or is a contractor, and there's a whole back precedent going back many, many years. But the key principle that we're working with nowadays is Section 6 of the Employment Relations Act, which says that there can be an inquiry into the real nature of the relationship. And it's there really because the legislation provides minimum standards for employees. So if a person is a contractor and they're not an employee, they don't get access to those minimum standards. And so what the legislation does is enables a process to ascertain what someone's proper status is or correct status.
And you talk about the duck test here.
Look, it's a nice way to explain it sometimes because these concepts can be a bit esoteric and legalistic, and really what the courts look at is what I call the duck test. So if it looks like a duck, walks like a duck and quacks like a duck, it's probably a duck, and calling it a chicken won't make any difference. So we can call our workers contractors, but if in reality they're actually more akin to employees or are employees, then that's what they will be held to be.
I think one thing that sort of comes out of this is how will it affect other cases that are being taken in other sectors that are looking at this. What do you think?
It's interesting. Like I can't help but draw attention to other sectors of the workforce. It's an interesting case in particular because it's dealing with a different type of workplace. These aren't people who come in on set hours and come into an office and work together. It's the gig economy, and it's not a traditional form of work. And so what the court has shown is that the legislation can apply to them just as well. It follows the law and the traditional application of the law, but it is an interesting way of doing it. But there's a really key statement in there at the end of the decision where the judge quite properly says that it applies to these 4 workers only and it doesn't have wider application. But she does also say that, it will undoubtedly have an impact on other workers who are engaged in the same way. So it's that balance between saying without saying, this does have a wider application, but it's primarily to the Uber workforce because it's those who have been looked at. So other workers who work for Uber currently who have the exact same setup as these 4, which is presumably most of them, could now say, well, aren't I an employee too?
But does it mean they have to take a legal case as well now?
I think it'll be interesting to see what happens next. So Uber has signalled they're going to appeal the decision, so it will go to the Court of Appeal, and it may be that they hold the status quo in the meantime with everybody. They'd probably be advised, honestly, to start a process or a plan to have people, to re-engage with people as employees because there's quite a lot of liability that now will be accruing for across the workforce.
Yes. And it's not just in New Zealand, is it? I mean, Uber's fighting this battle everywhere in the world.
Yes, with different results, I understand. I haven't followed the overseas cases closely, but there's a bit of mix, and they were referred to in the decision, but the judge quite rightly said that, referred to those decisions, they're interesting, but actually the New Zealand law is what applies here.
Uber had argued they were facilitators. Can you explain what the nut of their argument?
Yeah, it really took me back to when rideshare apps and these types of apps first came about, because it used to be about connecting, a driver. I'm going into town. Is there anyone who wants to come with me? And then, of course, out of that came the business of being an Uber driver. And so what the Uber companies argued is that really they're just facilitating the contract between the driver and the passenger, and they're there as kind of a conduit. And that was that was not accepted by the court. It was quite soundly rejected because actually Uber set the terms of the contract. They set the fares. I mean, we pay Uber, we don't pay the driver directly. So there were a whole lot of reasons why that was held to not be the correct argument.
Could they change their business model and still argue that people are contractors then? Is that one way they might address it?
It's a really good question. I think that is that is potentially possible. One of the things that was really important in this decision was the test they call the control test. So when we're employees, our employer has quite a lot of control over us in the sense of when we start work, the jobs we do, when we stop, when we go on holiday. There's a whole raft of things that an employer will have this legal control over. So you could presumably rework it to reduce the control. The Uber drivers are, if they turn down jobs, technically they can turn down jobs, but if they do, there's negative consequences. They can follow process and meet certain criteria to kind of get bumped up a higher level, but they can be bumped down as well. And so the reality is they're under quite a lot of really strict control. And what the court found is that those rules and regulations drive behaviour. So presumably they could loosen it all off and make it very much, we are independent contractors in our own business, and I guess that's possible. I think that it's subject to what the Court of Appeal says. They might really be looking at the reality of actually having to engage people as employees.
Notwithstanding that this will go to appeal likely, what are the consequences for Uber at the moment? What are they staring down at the moment?
Well, it's quite profound because if you're an employer and you've incorrectly engaged someone as a contractor, when in fact they're an employee, all of those employment minimum standards apply to that employment relationship, however long it's been going. Technically, there's a 6-year period, but which employees can claim back. But so if they took holidays that they weren't paid for, they now should be back paid for those holidays. They should be accrued holidays that they haven't received. If they took sick leave, bereavement leave, while they were engaged with Uber, they now should be paid for those days. Possibly the worst one, I don't know this for certain, but could be the minimum wage, because if you're a driver and don't get many jobs in an hour and don't earn much money, well, you're entitled to be paid the minimum wage for every hour of work. And so you can see that it's potentially really profound. I get asked to advise clients on their structures and whether a contractor structure is possible in a particular case. And you do have to be thinking about these things really carefully because the risk of getting it wrong is pretty large.
Yes, I can imagine. So on the face of it, without looking into it in too much detail, do you think courier drivers and so forth would have similar arguments put forward for them?
It's super interesting because courier drivers, there's been a few courier driver cases. One is very old and arguably not that relevant anymore. It's a case called TNT in Cunningham, and there was a more recent case as well. But they were very much argued on their facts at the time. This shouldn't change in principle and industry. It's applying the law as it is. But I think what it does is it allows us to go, well, actually, just because someone's engaged in an unusual or different or non-traditional conformist way doesn't mean that the legislation doesn't apply to them, which is kind of obvious, but actually, it's good to see that in black and white. Courier drivers, I think, have been carefully set up with the benefit of some case law. And so I suspect that they're a little bit more protected without knowing the ins and outs of how they're engaged.
Oh, that's interesting. And you say for the consumer, ultimately it means higher prices.
Look, I think it has to. One of the reasons why companies hire people as contractors instead of employees is it could be actually the right approach and entirely appropriate for their business. But if they're trying to wedge people in that, it's usually because there's a cost saving to be had. There's less administrative costs to begin with. There's not those obligations I've already mentioned. There's not the personal grievance regime that applies that brings some risk. So you have to look at it and go, well, if ultimately when the dust is settled and the Court of Appeal has done what they do, the decision is still that these drivers are employees, then I would imagine that some of the costs will have to be passed to the consumer.
Is it possible Uber drivers will one day come under the Fair Pay Agreement legislation?
Look, it's possible. If they're all employees, then there is nothing really to stop a union on their behalf saying, hey, we want to now have a fair pay agreement. And that legislation was passed yesterday, so it's an exciting time for employment law and comes into force on the 1st of December. So we can see that there will be these applications being made to have collective bargaining for these industry groups.
And just finally, Shelley, I know you haven't sort of delved into huge detail yet on fair pay agreements and what the implications are, but sort of what's your top line view of what's going on there?
Yeah, the top line view is for those of us who are old enough to remember the awards, like when I started work at a supermarket when I was 15 years old, it's a return effectively to awards. So these are industry-wide negotiated agreements to set the minimum standards for an industry. So for instance, to use the Uber example, if Uber drivers are employees and if indeed Ola and other drive share companies are employees, there could be an application made for a fair pay agreement to cover all of those drivers, not just at one company. It's the type of thing that we'll definitely see an improvement in terms and conditions for employees, most likely. I think it's going to be difficult to get them across the line because it's like a whole mindset shift for people. It is going to probably drive up costs for employers in terms of staffing costs, and it is a big infrastructure being sort of worked on and put into place now that if the government changes will be overturned. So we're in for potentially a little bit of a tumultuous time in the employment law landscape.
Yes, I just wanted to ask you finally, what is the likelihood or even the possibility or the ease with which a new government, a different government, would be able to overturn that legislation?
I mean, and you sort of look at that and think, gosh, you've put that into place, you've got this structure behind it, but actually they dismantle things in employment law all the time. You might remember they once completely privatised ACC and then the next government reversed it. And I think you can do it. There would have to be some work done on what happens to the agreements that are now in place. But if the Act was gone, next September or December, then everything would just stop happening going forward. I think that it's possibly unlikely, I might be being a bit pessimistic, but it's possibly unlikely that any of the agreements will be in place by then. There is a bit of a process around it. As I say, we will have to kind of feel our way. But I think we can be pretty confident that come 1 December there'll be some applications made to start the ball rolling.
Absolutely. Shelley, thank you very much for talking to NBR.
It's a pleasure. Thank you very much.
Thank you.